The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Thank you. Council, remote, can you hear us?
Yes, I can. Can you hear me as well?
Yes, very well. Thank you. You may proceed.
Thank you, Your Honor. May it please the court. Diana Stavroulakis, court-appointed CJA counsel on behalf of Mr. Dadisman, and I would like to reserve 5 minutes for rebuttal, please.
So noted.
The issue before the court today is whether the district court erred in denying Mr. Dadisman's motion to suppress physical evidence where that evidence was obtained in violation of his Fourth Amendment rights. And the underlying triggering event in this case was a traffic stop. And since a traffic stop is considered a seizure under the Fourth Amendment, it is reviewed for reasonableness based upon the standard announced in Terry versus Ohio, a two-prong test. First, whether the initial stop was lawful, and if so, whether the officer's actions thereafter were related to the scope and circumstances that justified that stop. And we would present to the court that the district court concluded that the stop in this case was reasonable because the parties agreed that Mr. Dadisman did not have a valid license plate on a motorcycle that he was riding, and that's what initiated the traffic stop. And that the officer's actions thereafter in detaining Mr. Dadisman until a canine unit could arrive on the scene for approximately a 10-minute detention wait was not unreasonable because of that length of time, that it was de minimis. And I would ask the court to consider the factual circumstances that led up to this traffic stop. And I think this is fairly conceded within the government's brief throughout their argument that this was never really about stopping Mr. Dadisman because of an invalid license plate. This was always about the Barber County Sheriff's Department investigating drug activity in that area. And they had tips or information that Mr. Dadisman was a big player, and they wanted to approach him and make contact and hopefully ultimately get more evidence to support a search warrant to go to his residence where they had information there was drug activity occurring.
But that
So,
is, counsel, you're not
Yes.
suggesting, or are you suggesting that there's a constitutional problem with what you've just outlined? I think.
There is not a problem with
Okay.
that. So they use this
So what
pretext
do you think
to
was
stop.
the problem? If it's not the pretext, why don't we get to the part that's the problem?
So the problem is after they do this valid stop, which is based on this invalid license plate, after they take whatever law enforcement steps are necessary, there has to be some reasonable suspicion to hold Mr. Dadisman at that location, which in this case was the gas station where they approached him. There has to be a reasonable suspicion that there's drug activity right at that time to hold him until this canine unit arrives. And Mr. Dadisman is arguing that there was no reason to hold him further, that he was detained and there was no reasonable basis to do so at that point in time.
Counsel, did you understand the district court to have asked and answered that question? Or did the district court, in your view, apply the right standard and then decide, okay, there needs to be reasonable suspicion to hold someone for 10 minutes, and there was reasonable suspicion here?
I don't think the district court went into whether there was reasonable suspicion for the entire 10 minutes. I think the court looked at the fact that that wasn't a very long length of time, number one. And number two, Mr. Dadisman couldn't have driven away anyway because he didn't have valid license. So I think the court now has to go back and review the facts that we had available to us through both the testimony of the suppression hearing and what was visible on the Sheriff Carpenter's video cam to see if that supports this 10-minute period of time where nothing is happening to, advance the whole reason why they stopped Mr. Dadisman, and they're just waiting there literally for a canine unit to arrive. And
Counsel, the way you give the facts, I must have missed some of the facts in this case. It seemed like you suggest that they stopped him and then held him for 10 minutes solely because of suspicion of drugs, but didn't something else happen too? They found out that the vehicle, or I shouldn't say the vehicle, the bike he was riding did not match the registration for that vehicle.
Well,
Is that correct?
it's my understanding that was the reason why Sheriff Carpenter initiated the stop. He received information over a cell phone call with another deputy sheriff that the license plate was not valid. So that's why he followed him into the gas station, pulled up behind him, and activated lights
So
and sirens.
you don't dispute that, right?
I don't dispute that.
Well,
And
if you don't
I
dispute
guess
that, then do you agree that they could impound the bike?
they could have, yes.
So you suggest that then that you could impound the bike in less than 10 minutes?
Well, I actually don't know how long it takes to impound a bike, but I do know that
You have
no
some
action
idea,
was
though.
taken to do that.
Well, didn't they impound the bike?
Well, if you're watching the video,
No, I'm not watching the video, but did they impound the bike?
ultimately one of the officers drove away on the bike, yes.
Right, okay. So you're saying that, so it wasn't just the suspicion of drugs during that 10 minutes, it was also the fact that he was riding a bike that didn't match the registration. So you're saying that was unreasonable, 10 minutes, then they could clearly hold him just for that. And we got plenty of cases say why they're holding for something else, they can bring a dog.
Well,
It's
I guess the
right?
problem I have, Your Honor, I'm sorry, I don't mean to
No, I'm
interrupt
sorry,
you.
you go ahead.
So after, the initial contact is made between Sheriff Carpenter and Mr. Dadisman. And shortly after that, over the length of this, the whole thing was about 15 minutes, but during the length of that time, ultimately there are 6 officers that descend on the scene. The officer that ultimately drives away with the bike is on the scene the whole time. Or not the whole time, I apologize. He shows up and he's standing, he's a plainclothes detective. He's not in uniform that day. So if that's impounding it, waiting for someone to drive it away, that officer had been standing there in the video for the 10 minutes that they waited. So there was what else were they waiting for?
We do it, okay, fair enough. Well, they did have to write a ticket, correct?
But they did not issue a citation.
Well, they don't
So
have to. The question is, they could have, based on what they found when they stopped him, write a ticket, correct?
that's correct.
And you're saying that to write a ticket could have been done in less than 10 minutes?
I believe so, yes.
Well, there's a whole
Sheriff
lot of-
Carpenter already
You gotta
had the
can-
information.
Can
He
you cite
didn't
a
have to
case that
call
we've,
that,
I'm sorry. Can you cite a case in the Fourth Circuit where we found that?
that
you-
it doesn't take
that
10
if you
minutes
take
to write
the-
a citation?
Someone
No,
took 10 minutes or less to write a citation, and we said that was a delay.
I don't have a case for that particular point, but I would note United States versus D'Angelo, where there was a somewhat similar factual circumstances where an individual was stopped under a pretext for a traffic violation, but ultimately it was to further the officer's drug investigation. And that's a 10-minute stop. And this court said in that instance that that was too much of a delay to dispense with what needed to be done that justified the stop.
Was they
And that
writing a citation? Or were they just holding them just for the suspicion of drugs?
The court determined that that's why they were delaying it, for the K-9 unit to show up in that case.
Did they pull him over for a traffic stop? Same situation as here?
In that situation, it was apparently for tailgating, driving too close to the car in front of it. But there was, to my recollection, no citation issued in that case either. But the ensuing conversation between that officer and that defendant focused on the drug investigation, which is similar to what happened in this case. While they're waiting on the scene, there's ultimately 6 officers present. They just used that opportunity to keep asking Mr. Dadisman if he had drugs on him. If he's honest, they'll work with him. They're willing to work with him about it. So in my view, there's no reason after they've stopped him, they can cite him. There was someone there to drive away on the bike. They had been waiting there the whole time. There's no further reason to wait there other than they were waiting for the K-9 unit to arrive.
Okay, now, counsel, there was a gun involved, correct? Not an illegal gun, but nonetheless a gun that they had to run a record check on. Isn't that correct?
You're right. There was
Okay, so
Mr.
that
Dadisman did alert them that there was a gun on the bike, correct?
So that took up about a third of the 10 minutes, did it not? seems to me that we're left, at least from looking at this record, with about 6.5 minutes that Mr. Dadisman has to argue about, not the 3.5 where the police were involved in actually stopping him for the infraction, for checking the gun and making sure that it wasn't an illegal gun. So we're down to 6.5 now. Was Mr. Dadisman at this point in time, in your view, could he have walked away since he was only being held on a traffic infraction and he wasn't stopped on the side of an interstate highway? He was stopped in a place he could have walked away from. And how
Your
does that
Honor,
factor
my
into your
response to that
analysis?
would be, and I'm sorry, I don't want to, did you want to finish?
Excuse me?
I didn't mean to interrupt you. I didn't know
No,
if you
that's
were
okay.
done.
No, it's hard. It's hard even in person, so
I'm
that's
sorry,
fine.
I apologize.
So
So
where are we left
my
then with-
response then is that there's a show of authority. You know, after the initial stop, 6 different officers arrive from throughout Barber County. So with that presence on the scene, I don't think any reasonable person would have felt free to leave. If he would have started to walk, there's 6 officers there that are all armed that could have stopped him.
Didn't your client admit to have illegal drugs?
After the K-9 unit arrived and the Raptor, the K-9 officer, did alert to a hit at the back of his bike, then he did admit that he had the drugs. Correct, Your Honor.
After he hit? You're
That's
saying
correct,
He
Your Honor.
didn't say anything about it. He had some meth on him before the hit? You sure about
The
that,
district
counsel?
court did make any certain finding about, there was conflicting testimony about that. And so the court didn't make any finding about that statement.
Well,
But
the court doesn't have to make finding of the statement for in terms of, what, didn't he say that when they asked, do you have any drugs? Didn't he say he did or not?
he did say that
Before
he
the
had it,
dog-
but it was
before
after the
dog
K-9
alerted on
alert.
the fender, correct?
I apologize, I didn't hear you.
Before the dog alerted.
He did not say before the dog alerted. It was after the dog alerted. And he went over, and then, to my recollection and viewing the video, he went over and pointed out where it was in the saddlebag on his bike. That's
What point did
correct.
the police officer see the bullets?
That was at the first part of the initial contact with Sheriff Carpenter. That's when they saw the bullets, and he was moved away from the vehicle and searched for safety.
Right, so you don't have any objection to the frisk for the safety of the officer, right?
Of Mr. Dadisman, when he was pulled away from the bike, that seems reasonable.
How
But
long
once
did
he
that
was
take?
removed,
How long did that take?
after the initial contact and he was moved away, I believe that part of it was just maybe 1 minute. The interaction between Sheriff Carpenter and Mr. Dadisman that we can see in view and that they've testified to is probably not more than 2 minutes. Everything after that is just other officers arriving and then waiting for the K-9 unit to arrive on the scene. So, and I don't think there's any minimum or maximum amount of time that's, triggers whether he's been detained too long. It's dependent on the circumstances. And I'm saying in this case, based on the show of authority, he didn't feel like he could leave, but they weren't doing anything further for the purposes of the stop. They already had the information that he had an invalid plate on his bike. They knew that. They could have written the citation, and the officer that ultimately drove away on the bike could have driven away on the bike. But that isn't what happened. They waited there till the K-9 unit arrived. And if I stated, I'm not sure if I stated earlier or not, I don't think it's any dispute with the government that this was all, the whole thing was really a pretext to stop Mr. Dadisman and to further the drug
Counsel, that's not unusual
investigation.
at all. You think that's odd? I mean, I couldn't tell you how many cases I've had since I've been on court over 24 years where officer, because you're in a neighborhood that's high crime and drugs, and then they say, well, let's see. Oh, they crossed over the line. Stop. Oh, they didn't signal for the right turn. Stop. Matter of fact, I can cite a case down, it was out of South Carolina where the police officers ultimately stopped for because they said the tint of the car, the window was too dark, but they basically said before that, they said there's something spooky about that car, spooky, before they even stopped them. And then later told that the registration people to hold up before you even bring the, give me the information that I've asked for about this vehicle, and they talk to them. So this, when you talk about pretext, that's not unusual at all. What's unusual about this case, really, in terms of pretext?
The unusual part, I believe, is what justifies them keeping him there for either between 6.5 or 10 minutes, whatever it's determined to be. And I don't think it matters if it's 6 minutes or 10 minutes. It's just why is he detained there longer than necessary for the circumstances that precipitated this traffic
Sorry,
stop?
Counsel, before you go, can I just ask a quick question about the record? There are these references to the tips that the police officers had when they pulled your client over. Is the nature of those tips in the record somewhere?
Not to my knowledge, Your Honor.
Thank you.
If the court has nothing further, then I'll mute until rebuttal.
Thank you, counsel.
Thank you.
Mr. Warner?
Good morning, I'm Stephen Warner. I'm an AUSA in the Northern District of West Virginia. I'm stationed in the Elkins Division. Good morning, Ms. Stravulakis, and may it please the court. This case is not about a traffic stop delayed to wait for the arrival of a canine.
Why not?
Sheriff Carpenter didn't even ask for the canine. He didn't ask for the canine. The canine only arrived because another officer in a different police agency, the Philippine Police Department, not the Sheriff's Department, heard radio traffic. It's not common in Barber County and Philippine for people to help each other, but the police chief heard radio traffic that there had been a traffic stop on Dadisman, and the police chief ordered his canine to go to the scene to assist. The sheriff who made the stop did not ask for the drug dog.
Did he know the drug dog was coming?
At some point in the record, he said that he heard in radio traffic
Okay.
as he was there from his car that a drug dog
I mean,
was on
are
route.
you asserting now, and I think this would be for the first time, not before the district court and not in your briefs, that the people on the scene were not waiting for a drug dog?
I am asserting that, yes.
Did you
And
say that to the district court or in your written brief? Because this is the first I'm hearing about it.
I think it is in my brief that the Sheriff Carpenter did not ask for the canine.
Right, but
And then
I'm
of
asking a
course-
different question. I don't care who asked for the canine. I care whether the officers on the scene were waiting for a canine. And if it's your position that they weren't, I'm curious as to why this is the first we're hearing about it.
Well, I think I said in my argument, and the district court found, that the sheriff stopped the car with the intention of impounding the motorcycle. So this is a case.
Just before we move on, is your position today that the people who were holding Mr. Dadisman at the side, or I guess it was in a gas station, were not waiting for a canine? It's just they were all surprised when the dog showed up. Is that your position?
No,
Okay.
they knew the dog was coming.
Okay.
Well,
They-
they were
they-
talking to Dadisman about drugs during this 6.5-minute interval, weren't they?
Oh, it's
I mean, they
definitely
were
a pretext.
talking, there's no evidence in this record that they were talking about the mission of the stop. In other words, we've got to impound your vehicle. These are the next steps when you have an improper registration. I need to fill out a citation. None of that. They were talking to him about drugs. And-
Absolutely correct. Yes,
Right.
yes, Your Honor. That is
So,
right, yes.
so what do we do in a case like this, Mr. Warner, when it's the government's burden
Yeah.
to show that the officers were carrying out the mission of the stop? And the mission of the stop was the improper registration and the need to impound the vehicle. And the record is pretty much silent on what they were doing after they did the record check on the gun. How do we deal with that analytically?
Okay. The motorcycle is stuffed with baggages. There's, I think, evidence in the record that it was 3 feet high with stuff on the back of the motorcycle. It's not that easy just to impound the motorcycle. And
Do we know that from this record?
there definitely is a comment in the record, I think in maybe my second response, that it was 3 feet high with stuff.
No, but there's nothing in the record about an impoundment procedure or steps that were taken to impound the motorcycle or anything like that. There's nothing in the record saying that their usual practice would be to impound the motorcycle, or that their usual practice would be that they wouldn't let the rider just walk off, even if it takes an hour to impound the motorcycle. Why does he have to wait? There's nothing in the record about any of that.
Well, here's what I'd like to leave you with, and I hope this answers your question. I would argue and propose to you that it's not that easy. The court found, and the district court found, the sheriff intended to impound the motorcycle. And we're talking about taking a motorcycle from an armed drug dealer in a public parking place.
But your briefs in the district court, if I read them right, said that it took 3.5 minutes to do a protective sweep, make sure that the defendant wasn't within grabbing distance of a gun, get the scene under control, and then another 6.5 minutes waiting for the drug dog. And so my question is, what accounts for that 6.5 minutes?
Because I don't think I argued that the scene was ever safe, and I wouldn't argue that at all today.
Where was Mr. Dadisman after the first 3.5 minutes while you were waiting for the drug dog?
Somewhere within 10 feet of the motorcycle. And the court found.
But you'd already swept the motorcycle. You've frisked him, he doesn't have a gun. You've swept the motorcycle. There was a gun, but now it's under police control.
No.
No?
The officer did a very limited search to specifically where Dadisman said there would be a gun in the motorcycle, period. The officer didn't search the motorcycle, but only the one specific area where Dadisman said.
So you thought there were other guns on the motorcycle, but you didn't look for them? You didn't, because I thought you conducted a protective sweep under long of the motorcycle. Is it your position that the police officers on the scene thought there were additional guns on the motorcycle, but they left Mr. Dadisman within lunging space of that motorcycle nevertheless? Because that strikes me as entirely implausible.
No, it's my position that it wasn't clear there was a scene just because one gun was taken from a saddlebag. This is a public place. Was there a co-conspirator?
Can I just ask you a quick question?
Yes, ma'am.
It seems to me that the reason we are here today is because the district court applied the wrong standard here and didn't make any of the factual findings that would be necessary to validate what happened here. The district court didn't apply Rodriguez. It didn't make a finding as to whether this stop extended beyond what was required to carry out the nature of the stop, and it didn't make a finding as to whether there was reasonable suspicion. So how are we supposed to do all of this on appeal for the first time?
Well, the district court found that the officer intended to impound the motorcycle, and that could not be done in a 10-minute period as the officer.
You think the district court found that there was not time to? So you believe that the district court somewhere in here found that this stop was not extended beyond what was required to meet the needs of the traffic stop? Just can you give me the JA page for that?
I can't, Your Honor, but I would
Yes,
say
because
the district court
didn't
found.
find that.
The district court found the motorcycle was not free to leave. The motorcycle was not going to leave. The district court did find that. The drug dog could have hit the next day at the impound lot. I would argue to you that it's not about a drug dog case. It's about impounding that motorcycle. And
That's not what the district court said. The district court just said 10 minutes isn't that long. The district court applied the standard from McBride, which does not apply to traffic stops. It applies to a Terry stop because you have reasonable suspicion of ongoing criminal activity, and under those circumstances, the stop can't last longer than necessary. It applied that standard where it's not supposed to be applied, and it didn't apply Rodriguez, and it didn't make the factual findings we need.
Because the court found that the motorcycle was to be impounded upon the inception of the stop. So the motorcycle was already in the police custody from the inception of the stop.
Well, if the motorcycle was here making the case, that would be highly relevant, but instead, Mr. Dadisman is here making the case, and I'm just not, like, I may be really misunderstanding your argument, but is there somewhere in this district court opinion that applied the Rodriguez standard, the two prongs? Was this stop extended beyond what was required to take care of the traffic stop? And if so, was there reasonable suspicion? I just can't find it.
No, the court found that the police intended to impound the motorcycle, and I would argue that at that point, in the beginning of the stop, the motorcycle.
Right, but was the court confusing impounding the motorcycle with detaining Mr. Dadisman? Those are two different things. Yeah, aren't they?
So where is he?
In terms of the analysis that we have to apply, we're talking about the person being detained. We're not talking about the motorcycle being detained. So it seems to me that the court kind of got off on the wrong track on page, I guess it's page 10 of its order. Or I'm not sure if I'm giving you the right page number here, but it would be JA 207, when the court was saying that the parties agreed that the motorcycle had improper plates and that Dadisman could not have driven it away. Under these circumstances, the period of delay was reasonable. Well, again, that's talking about the motorcycle being detained and not Mr. Dadisman. The court seems to think because there was a problem with the motorcycle that they still could have detained him. And aren't those two different concepts? Aren't we concerned with the detention of the person rather than the motorcycle? It isn't the side of the highway, you know, on an interstate, where detention of the motorcycle would be detention of the person per se. You know, a person couldn't go anywhere if the traffic was speeding 65 miles an hour by him. But here, we have a different situation where arguably he could have walked away. So it seems to me the district court got on the wrong track, talking about the impoundment of the motorcycle when he needed to talk about whether the police were pursuing the mission of the stop so as to justify the detention of Mr. Dadisman. Isn't that correct?
I hear it respectfully.
Or if not, why not?
No, I think it is correct. I think you're correct. But I also think the defendant didn't raise as an issue below the detention of himself. I think that the motions filed by the defendant down below were the detention of the motorcycle. I'd have to double check that, but I think that was the focus of the whole proceedings down below, is the search of that motorcycle.
Look, it's, okay, so your brief before us argues primarily that there was reasonable suspicion to justify this stop, and then in one sentence says also the length of the detention was not more than necessary to impound the motorcycle, as Carpenter intended. I actually read your brief to be giving that one up, and properly so, because there's a difference between the motorcycle and Dadisman, and arguing the reasonable suspicion point, but you believe you preserved the sort of initial question as to whether this stop extended beyond what was required to satisfy the needs that go along with the traffic stop? Because I don't really see it preserved in your brief, is what I'm saying. Because, you know, our passing shot doctrine, you can't say something in one sentence and not actually argue the point.
Okay.
No, it was a question. Do you think you have preserved that argument in front of us?
I think I have. I think in the briefs, it's out, even if it's one sentence in the end. I think the focus is, my argument in the focus is that the decision to impound was at the inception, and the case should be over at that point.
Counsel, you alluded to, you said, well, the dog could have hit on the motorcycle the next day. That you suggested that it was inevitable discovery?
No, I wouldn't make that argument. I wouldn't make the inevitable discovery argument. It's not that easy to make that one, and I
Well,
didn't
you
make it below. But
you didn't make that in the district court,
You didn't
Right.
make
or on
that.
brief here.
No, you didn't make it here, but why would it be difficult if you said the impoundment is justified? Why would it be your case that it's inevitable discovery? Well, like you said, you impound because that's what we're talking about, suppressing the evidence that came from, it's concealed in the bike, right?
That's right.
But then when you impound it, then the dog could have done what he wanted to do.
That's right. There would have been a duty to itemize the evidence that they
Why do
impounded.
you
We
think
didn't
that
develop
would,
that.
why do you think that would not have been a strong argument for you?
I think it would have been a strong argument.
Yeah, I'm
yes.
wondering why you didn't argue that. You didn't, though.
And this court has said you have to make the argument in order to prevail on the argument. In other words, that's not an alternate basis for affirmance if you didn't make it.
No, I didn't make the inevitable discovery argument below. No, I did not.
Okay.
Okay, nothing further than
No,
I'll
I've
say.
got questions.
Yes.
Are you aware of anything in the record about the nature of these tips? That, I mean, your argument in your brief is that there was reasonable suspicion. that he was dealing drugs before he was stopped. And so you base that largely on the tips, and I'm wondering whether there is anything in the record about the nature of those tips.
There's not. There's evidence in the record, the testimony that there were more than one tip that caused the sheriff to believe he was a, quote, big player in the drug business.
But we don't know if it-
That's the evidence.
Yeah, okay. Is there some reason that nothing was put into the record about sort of, the fact that the district court applied the wrong standard wouldn't necessarily mean we couldn't affirm if there was sort of stuff in the record that would allow us to apply the right standard. But I can't find anything about the nature of the tips. I can't find anything about standard practice in a case like this, whether it is in fact true that they would impound the motorcycle, and if so, how that would work, how long it would take, whether they would require the owner of the car or the motorcycle to wait for the duration of the impoundment. There's just nothing in the record. What happened here?
You're right about that. Yeah, there's nothing more about the tips, and we did not develop impoundment or inevitable discovery. That's right.
Why, it's a question, why is the record so thin in this case?
Well, I think the focus of the whole, another focus of it was the danger to the police at the time that they made the stop. They have within 62 seconds they know this defendant has a gun, and there are tips that he's a drug dealer. And they're in a public place with people walking. There could be a second weapon. There could be a weapon on his hidden. There could be a co-conspirator in the crowd walking in the parking lot. It was a very dangerous scene. Why didn't they just secure him? The police are entitled to do so many things to secure a scene if it's dangerous. They could have put him in the back of a squad car. Like, I don't understand. If they thought it was dangerous and an unstable scene, why did they leave him standing within 10 feet of the motorcycle? Well, I propose to you they didn't leave him. They engaged him. The sheriff engaged him.
Why didn't they engage him in the back of a squad car? I've just never heard of a case like this where the police have a concern about the stability of the scene. The law gives them so many steps they can take to protect themselves and bystanders. They didn't take any of them here. Why not, if they were worried about that?
Because I think I would argue that Sheriff Carpenter did a very good job in a public place to keep the peace and calm down by slowing it down and engaging Dadisman in a conversation as he zeroed in on the issue. Within 3 minutes, he knows Dadisman has a gun, at least one gun, and that he's a drug dealer. And I would argue to you that Sheriff Carpenter did a nice job of keeping it calm in a public place without having a scene and waiting for the rest of the officers as they all finally came in. But I would argue that Sheriff Carpenter did a very nice job of keeping the peace in that scenario, in that public place.
Well, let me ask you, Mr. Warner, what was the West Virginia code section under which Mr. Dadisman was stopped?
It is in the magistrate's report and recommendation. The code section is cited 17.
Right, and the reason why I'm asking you for a particular code section is, does West Virginia treat it as a criminal offense or purely a traffic infraction?
I believe it's a criminal offense, and I used to do that defense work before. So I would want to look at the book again, Your Honor, but I think it's a criminal offense for which you could go to jail for.
So you're saying you could go to jail in West Virginia for having an improper registration?
I would want to look at that. It's been 25 years since I've done state court work, and I didn't look at that statute before coming in, the penalty on that. But it is cited in the magistrate's report and recommendation.
But and on a different subject, you do agree it's the government's burden to make the record that the officers were pursuing the mission of the stop?
Yes, ma'am. Okay.
All right,
Thank you.
thank you, counsel. Counsel, you have time reserved.
May it please the court, I did reserve 5 minutes, but based upon the exchange during Mr. Warner's portion, I would rely on that, but leave myself open for questions if any of you have any questions of me.
Let me ask you one question, Ms. Stavroulakis, and that is it an option for this court to remand this case to ask the judge to conduct the analysis that should have been conducted? Or is it your position that it's a one-shot deal, the state had its chance, and remanding for the proper analysis is not within the scope of the appellate procedure here?
I think that the court can remand for appropriate proceedings, but we would argue that the court could look at the record as it stands and make their own determination that there wasn't a factual basis in this case or a reasonable suspicion to detain Mr. Dadisman any longer on the scene.
All right, nothing further. All right. Counsel, we note that you are court appointed, and on behalf of the Fourth Circuit, I'd like to note that, and a special thanks to you, and we rely on lawyers like yourself to take these cases, and we appreciate it very much.
Thank you, Your Honor. I appreciate it.
And obviously, Mr. Warner, we appreciate your representation of the United States. We'll come down and greet counsel and proceed to our next case. We'll have to give you a virtual high five.
Thank you, Your Honor.
Maybe seated. Counsel, when you're ready. Mm-hmm.
Good morning, Your Honors.
Morning.
Please the court. My name is Kristen Farr. I represent the appellant, Mary Frances Harkert, in her case against the Social Security Administration. Ms. Harkert is an ambitious and dedicated federal employee.
Excuse me, counsel, could you speak up a little bit?
Hey,
Yes.
pull your mic down a little bit. It'll help a little bit. That's good, right there.
Sorry, a little shorter than prior counsel. Ms. Harkert is also an individual with several disabilities that require consistent monitoring and treatment. Therefore, she has several medical appointments every single month, and she requires time off work or a flexible schedule to attend those medical appointments. She took this job at the Social Security Administration in 2015, leaving a position at the General Services Administration, and at that time she tried to ensure that she would have the same accommodations as it related to telework when she went over to the SSA. Although there was some issue with getting that taken care of, she eventually got 1 day a week of telework, and then she also took advantage of SSA's episodic telework. And that worked relatively well until August of 2017, when her supervisor denied a request for episodic telework. And at that time, she escalated it. She sent an email on August 14th of 2017 to her second and third line supervisors, specifically saying that she needs a reasonable accommodation and wanting to speak to them about it. 4 days later, she has a meeting with her supervisor to discuss alleged performance deficiencies. It is clear from the record that her first 3-level supervisors did not like the fact that she was taking all of this episodic telework. The common theme throughout it is that she is taking this for convenience, that she wanted to take telework whenever she wanted to, but her reasonable accommodation clearly states a time frame. She requested 2 to 5 days per pay period. She was already having 2 days, so that's just an additional 1 to 3 days of telework per pay period. Her supervisors wanted her to essentially to use this telework for her medical conditions, and when other things would arise, that's really where the conflict came up. But episodic telework is a term and condition of everyone's employment. And if she is not allowed to use telework for other things as well, unfortunately, being disabled does not exempt you from having your garage door break. It does not, you still have family that will come in town to visit you if you're disabled. You still have to sit in traffic if you're disabled. So all these things that a non-disabled employee can take advantage of and use the episodic telework to use their regular day of telework to deal with these things, Ms. Herkert was essentially not allowed to. When she wanted more episodic telework or more approved telework, her supervisors essentially accused her of, taking too much time for getting more than what she deserved.
If I can just jump you ahead a little bit, counsel, in the end, right, your client got what she was asking for. She was reassigned to a job where she would have more flexibility and she could get I think it was 2 days a week. So maybe.
Right, with
Yeah.
that came at the expense of her supervisory duties.
Okay, so let's talk about that.
And so you have the first reassignment, which is really the most severe. This comes in the end of September when she is, even though it's the same grade, same pay, she is in a position that she formerly supervised. And that is embarrassing. I mean, you are now peers with the people that you used to supervise. And you still have to deal with these people that you have alleged have discriminated against you. They were still in her supervisory chain. So
if you could address this in a legal context, what you're saying is this makes it an adverse action?
Yes, it's an
Okay.
adverse action. And for the disability claim, I think it's clear that Muldrow v. St. Louis, there's no heightened material adverse standard anymore. It's just some harm. And I think certainly being transferred to a position that you used to supervise constitutes some harm.
But the record
Okay.
said that she was excited about the transfer, didn't she?
That's the second transfer.
Oh, the second one. Okay, this
Yes.
is the first one. Okay.
Yes, this is the first one. I
Okay.
think it's clear that constitutes some harm. Now, she was given the opportunity, after she complained to her fourth level supervisor, that she was then given another position. Now, this is still not a supervisory position, but it takes her out of the chain of command that she is having conflict with, and it takes her away from the people that she used to supervise. So now it's not coming into work and having to see these people that you used to be their superior, and now they're your peers. So she does accept that. And yes, she did not want to burn bridges. She thanked her fourth-line supervisor for that opportunity.
Well, was
but it
that an adverse action?
Yes, I think that is still an adverse action.
Because it was not supervisory, you're saying per
Yes.
se it was adverse?
Yes.
Okay, well, let me just ask you a hypothetical then. You're saying if someone goes from supervisory to non-supervisory, it's always adverse? What if you were going to non-supervisory and getting a $25,000 pay raise? Would you still say it was adverse? You see what I'm saying?
Right.
I'm
I
not
mean,
sure it's
obviously the
categorical
context-
like that.
The context matters.
Okay,
Sometimes in your career trajectory, you get a promotion that takes away supervisory duties.
okay, so
maybe.
you're
That's
saying
still
it
a
doesn't
promotion.
matter that it was a different division, that nonetheless it was non-supervisory, so it was adverse.
Yes. And it's clear,
How
she
do we
wanted to
deal
be a
with her?
supervisor.
How do we deal with her email? Are you saying then saying that she was grateful for the opportunity? Are you saying that simply goes to a question of factually as to voluntariness? Or how do you work
Yes,
her response into the legal framework that we have to consider?
right, I think that's a question of fact as to whether or not that's truly voluntary. I don't think that, she was grateful not to have to be in that other position, but that does not mean that she is grateful to have her position stripped from her. I mean, these are two different analysis.
So in
And-
the context that you're saying, you'd never have summary judgment because it would always be a matter of fact. Well, I just felt that I wanted to be a supervisor, and that's the way I feel, even though I was excited and put it in writing at the time, but now I just felt, so you'd never have summary judgment because you would say, it's just totally a state of mind, right?
Well, I mean, as a plaintiff's attorney, sure, I guess I'd always say that summary judgment is
Oh, my
inappropriate.
goodness, but we have to construe by the law, don't we?
I don't think that that is,
I mean, the standard would be incredible. You would say, you have in writing, say, I was excited about the job, but now you bring a suit and you say, well, I said that, but now I really wanted to be a supervisor, even though I remained a GS 13, and matter of fact, later got a.
I think it has to be taken in the context of the two reassignments. If there was just one reassignment that this fourth line supervisor had offered her, then yeah, it's a little bit more murky about this email saying, thank you for this opportunity. But the fact is, she wanted to get away from this extremely bad transfer that she was appreciative. And I don't think that that destroys the voluntariness of her.
So in the legal context, you're saying the issue is a jury question? That
Yes.
there is a disputed issue as to whether she actually was accepting the second demotion, the demotion outside her division? Is this what you're saying?
Her choice was between the two non-supervisory.
Yeah, you're saying
roles.
there were two bad options.
Yes,
And that she wasn't accepting either one of them, that she was grateful for being given the opportunity for one that was less.
yes. I think that's distinguishable from the
Negative.
case that the
Okay.
district court relied on, where there was this negotiated agreement to be in a different position.
My goodness, how would the employer ever have a defense? I mean, for example, I mean, every case, you would just say that, it'd be like, well, I control my own feelings, and I felt that this was a demotion because I want to be a supervisor. What would be the defense to that? I mean, I can't go inside your mind. I don't know what you're thinking right now. But if you said that's what I'm thinking, I can't really challenge that because I can't get into your mind. But we do have evidence that she said she was excited and it was in writing. So you're saying that that would withstand any summary judgment motion always because you could never get in her head what she really was thinking, right?
I think the case that the court relies on, where there was agreement with a reasonable accommodation in a new position, like that kind of situation, you can see that was voluntary, that
put
they
it in writing.
agreed.
She said she was excited about it. It was in writing,
About
wasn't
the
it?
second, it's between the two bad choices, though. At this point, she's
Between the bad.
mitigating her damages as she has an obligation to do.
Can I just add, I want to make sure I understand the facts. So she's told at this September 27th meeting, you're going to be a management analyst. You're not
Yes.
going to be a supervisor, you will be a management analyst. And so you would say, that's the demotion.
Yes.
And then she's told, instead of being a management analyst in one branch, you could be a management analyst in a different branch. But either way, it's a management analyst position.
And it's a
And
demotion.
your position
Yes.
is, your view is that that is a demotion from being a supervisor.
Correct.
Okay, so the demotion happens on September 27th, and after that, there's some jockeying about in which office she will perform this demoted position.
Correct.
Okay.
And I think obviously there are some exceptions. Some people don't want to be supervisors. But, I mean, as far as a hierarchy goes, generally, a supervisor position is one of higher prestige. And Ms. Eddington, the supervisor of the plaintiff, even acknowledged that in her deposition. Like, this is taking away your duties, that would be a negative.
Is that a jury question or something that you think a court can decide as a matter of law, whether after Muldrow, whether this was an adverse action? Putting to one side the voluntariness question, would that go to a jury, or do you want the district court to consider that question as a matter of
To determine
law?
whether there's some harm.
Yeah, whether or not what happened here counts as an adverse action under Muldrow.
I mean, I think that is something that defendants are still going to file summary judgments even after Muldrow, and that is the question for the court. And I think they can see that there is some harm.
So you think a
from the
district court could, just as a matter of law, this was an adverse action? Because I think that sort of takes you back to Judge Keenan's question about, like, well, sometimes a loss of supervisory duties wouldn't, in every context, be an
Right.
adverse action.
Yeah, I mean, I still think it depends on the context. I
Okay,
mean,
yeah, I'm sorry, I didn't mean to interrupt, but maybe it would be helpful in the context of Judge Harris's question, if you could tell us what the disputed issues of material fact are in this case that preclude summary judgment.
Yes.
And whether it was an adverse action, is that a disputed issue of fact? Is it a mixed question of law and fact? What do we have
I mean,
here?
I think it's a mixed question of law and fact. I think it is certainly before a jury, the defendant can raise the question of voluntariness and cite to this email, but I think that that's something that the jury, as the finder of fact, looks at the context, looks at the credibility of these witnesses as to, what is being offered to her, why it's being offered to her, and that's a question for the jury to ultimately determine, what the harm is.
But I'm interested in manager, many times, is a connotation, at least, that you do supervise people. I mean, for example, say, what do you do? I'm a store manager. Well, I've never been in the store before, but intuitively, I would think, oh, well, then you manage the people who are sale clerks. Wouldn't you? And that supervise them? Isn't that supervise them? Right?
Yes. Yeah,
Right.
a store manager, I would say, is a supervisor.
Or the manager you're doing here, too. What are you managing? Not people?
I guess maybe, what
How
is a
about
management analyst? What does a that was.
Oh, I see, I'm sorry.
It says manager. I mean, I wouldn't suggest that she worked at a store. I think that was pretty clear. What I'm saying is that she's a manager. What does she manage? Who does she manage?
She's a management analyst.
Or
and she-
management,
Yes,
or not managing.
yeah, so she's not supervising
the ma-
anyone in this capacity.
And she didn't want to do that.
She wanted to be a
Under
supervisor.
any circumstances, she would be excited about it. You're saying it's totally a Hobbesian choice. That's what you're saying.
Yeah, she did not want to be a management analyst
So I don't
in
see
any
the-
division.
Right, so then I don't see how any circumstance, from terms of a fact question, that it would be anything but the jurors to look people in the eye and who's credible, who's not credible.
Yeah.
Yeah. But you said this case started in August, but didn't it start problems in April? Some issues?
Well, they go back in time to try to build a case together. She received a positive midterm evaluation in April, and they claim that there were performance issues.
Right, that was well before she filed any kind of.
They did not bring that to her attention until afterwards. So after after she made a reasonable accommodation request, then they went back, put together a list of her alleged transgressions and said, you have performance issues, we have to
But
demote
she
you.
said there was a question of, she said, I didn't have a time frame, so it's not late, right? So that incident, she knew what they were talking about, correct? Wasn't there a question about an assignment she had?
With
In
her
April,
evaluations?
With April,
In April.
yeah. There was no question about her performance at all, job performance?
No.
Okay. Okay.
Good morning. May it please the court, Matt Shea from the United States, and the appellee, Leland Dudick, the acting commissioner of the Social Security Administration. This case is about an employee who voluntarily accepted a reassignment. The
Counsel,
district-
as long, I have so many questions about the voluntariness here. The allegation, at least, I think, is that a decision is made to reassign the plaintiff to a non-supervisory management analyst position. That's not voluntary, it's a decision made by her employer, she's informed of it, and that's the adverse action. And then after that, she is sort of allowed to pick between two management analyst positions. But I don't see how that makes the original decision to make her a management analyst, I don't see how that makes that voluntary. Do you see what I'm saying? Like, let me give you a hypothetical. What if I say to someone who works for me, sorry, I'm gonna let you go. You can leave now, or you can stay till the end of the week. And he says, I'll stay till Friday, and I'm so excited about the opportunity to stay until Friday. Like, it seems that your position would be now he has voluntarily quit rather than being fired.
I would not say that for that hypothetical.
Okay, well, what's the difference between that and what's alleged here?
Yeah, so the appellant in this case talks about this first transfer. There was no first transfer.
Right, I agree. It looks to me like there was one demotion, and then she got to pick in which office she would work under this demoted title.
So I would say it differently. There was an initial discussion with her second and third line supervisor where appellant was told, you'll become a management analyst. But she did not want that position. So she said no. She reaches out to the fourth line supervisor, Jim
If
Julian.
she says no, they tell her you're gonna become a management analyst, and she says, no, I'm not?
Right, she reaches out, so that's
No,
a
no.
conversation with the second and third line supervisor.
But you believe when she is, because I did not see that in the complaint, that when she is told from now on you'll be a management analyst, she said, no, I won't, and I'm gonna take steps to make sure that won't happen. Like, I don't recall her anywhere in discovery any indication that when she was told you're gonna be a management analyst, she said, oh no, you've got another thing coming, that's not happening.
So I think that it was an in-person meeting, and I don't know what words exactly
Right.
were spoken in
Right,
that
I'm
meeting.
pretty sure, okay.
But what happens after that meeting is that Ms. Herkert reaches out to Jim Julian, the fourth line supervisor. Right, so let me find the timeline here because it's important, I think. So on September 27th, 2017, Ms. Herkert is told she'll be reassigned to the position of management analyst in the Office of Building Management, excuse me, where she was.
She's told that that will happen.
That's correct. She did not want that position, so the agency did not force her into it. After that September 27th meeting, Ms. Herkert reaches out to Jim Julian. He's the fourth line supervisor. September 27th was a Wednesday. Ms. Herkert's on leave Thursday the 28th and Friday the 29th. That's at JA 224. The following Monday is October 2nd, 2017. Ms. Herkert meets with Mr. Julian on that date. Because Ms. Herkert did not want the previously proposed position, Mr. Julian offers an alternative. She accepts. 2 days later, October 4th, 2017, Ms. Herkert emails Mr. Julian expressing her appreciation. She said she was very excited about the transfer and most grateful to him for making it happen. Ms. Herkert is essentially asking the court to ignore this timeline and instead
I
rule
don't
on
think
an
she is. I think she's saying that a jury gets to figure out what happened here. Because even just sort of the text you are reading, I think a reasonable jury could say, here's what happened. First, she gets demoted to management analyst, and then she gets to bargain a little bit about in which office she will work as a management analyst. I don't think there's only one way to understand what you just read me.
Well, there's no first transfer. There's no SF50, for example, saying that she's in this management analyst position in OBM, right? It's only the second, what Appellant calls the second transfer. It's only the new position as a management analyst doing nationwide leasing that happens. So the proposed position, I don't think can be seen as an adverse action. It's just it's something raised in a meeting. It never goes through. It never happens. She never works that job, even for a day. So the issue of Ms. Herkert voluntarily accepting the reassignment is dispositive of counts 1 and 2. Count 1 was disability discrimination, and count 2 was retaliation. And we've been over the email. This is at JA 196. This is the critical email in this case. She says, "I am very excited for the opportunity to participate in our national leasing initiatives. I am most grateful to you for making it happen." The email shows that the assignment was not just voluntary. She's excited about it.
But she says that was a Hobbesian choice. Can you explain that? That's important here. She said that, it's like hitting you in the head with a hammer. It feels nice to stop, but you're still hitting the head with a hammer.
So, Ms. Herkert doesn't point to any authority saying this is, because this first position was proposed, therefore the second is not voluntary. And it's, not exact, but it's very similar to what the facts in Laird v. Fairfax County. In Laird, the court held, if an employee voluntarily requests a transfer and the employer agrees to it, there is no actionable adverse action. That's similar to what happened here. Ms. Herkert is arguing that her case is different because of this first proposed reassignment. But she says the court should instead focus on that position. And that's telling because, the case really is similar to Laird. She never worked in that other position. She said no to it, asked for something different. The agency says okay.
Can you help me? What is a management analyst? Because it's interesting, when she was a supervisor, it was at the same grade. Not only the same grade, but also the same step. What's the difference? I mean, normally if you supervise, you make more money, but there's no loss of money, neither grade nor level, scale. So you work with anybody in a cubicle as a management analyst? You don't deal with people?
Sure. So your point was absolutely correct. She's making the exact same salary, same grade, all of that, same benefits. She's managing a team of 6, and she's working in her previous position when she was a supervisor. She's managing what's called the outlying buildings of the Social Security Administration's headquarters. It's the leased buildings on their campus.
Mm-hmm.
So she has a team of 6, but she's in charge of reviewing the contracts, the work orders for these specific buildings, a few buildings, janitorial services, pest control, trash removal, these kind of things. That's what she's doing before. When she becomes a management analyst, she shifts to nationwide leasing, procuring spaces for the agency nationwide. Social Security Administration is everywhere. So she's now working on national leasing initiatives, and in her email, she says she's excited about that. And this is, similar to what she was doing on track for at GSA, so before she came to this agency.
So, Counselor, are you defending the district court said there was no adverse action on 2 grounds. One was it's voluntary, and the other was that there's no cognizable harm here. And this was, of course, before Muldrow, and so the district court said there's not a significant harm. But are you defending sort of that second rationale post-Muldrow? You think there's just no harm here at all between these 2 jobs?
I am. So I would say the court should affirm for the first reason. That's the primary holding. That was the main point of the analysis in the district court's opinion. And I think the court should affirm for that reason. But I would say there's no harm here.
So, just as a matter of law, like losing supervisory responsibilities can never be a cognizable harm?
I wouldn't say never. it's certainly a factor that the court can consider, but it's one piece of the puzzle,
But,
right?
okay, but if the benefits, if the benefits are the same and the step and the grade are the same, if all that's happened is you've lost your supervisory responsibilities, that's not a cognizable harm?
Well, if that's all that happened, it would be a different discussion if, for example, if she was actually placed in that first management analyst
Yeah,
position.
well, I guess I'm sort of asking you, the district court treated these as alternative. One was the voluntariness issue, but putting that all to one side, assume this is not voluntary. Then if salary is the same, benefits are the same, grade and step are the same, and the only difference is you're not supervising anymore, is that a cognizable harm?
It's not in this case.
Okay, why not? But for a reason that has nothing to do with the voluntariness.
So the Supreme Court in Burlington North v. White says this is an objective standard, not subjective. What would a reasonable employee think based on the totality of the circumstances, all the circumstances? So
Okay,
here,
does that make it a jury question?
not necessarily. I think the court could find as a matter of law here that there is no harm whatsoever.
And why not if she used to be a supervisor and now she's not anymore? That seems pretty important to me.
Again, it's one factor. One employee.
What are the others? What are the other factors?
The work in the new position is nationwide leasing, right? She's managing a few buildings, and now she's procuring space for the agency
Yeah,
nationwide.
but she used to be a supervisor, and you're saying that wouldn't even go to a jury, whether that counts as a harm? So what if the employer had said, look, it just feels weird to me to have women bossing men around, so everything else is gonna stay the same. You're not gonna be a supervisor anymore, but same pay, same benefits, same grade, and you know what? To sweeten the pot, now you get to work on national leases. That's fine, that's not a Title VII problem.
I think that would be a very different
Why?
case, Your Honor.
Like, I've kept all of the relevant factors the same as your hypothetical. All I've added is it seems, kind of like a bad motive, but, I mean, is that something you would say? Whether there's been a cognizable harm or not turns on the employer's motive? Because that sounds like a jury question.
So I would say the question of this, if this reaches harm, could be a jury question. But to your point of the employment discrimination in that hypothetical, the facts here are extremely different, and that's
Yeah, but usually when we consider whether there's been an adverse action, that is a question that is distinct from why it happened. That's what you get to when you start shifting burdens. So I guess I was looking for an answer that didn't turn on something that's not relevant to that inquiry.
But in the context of this case, in the sense that it could be viewed as a reasonable accommodation, because wouldn't this job give her more opportunities to have the episodic or scheduled virtual? Because then she would have more opportunity, and that's what it all started from, needing this for medical purpose, wouldn't it? When accommodation means you don't get exactly what you want, it has to be a reasonable accommodation. That is, you don't lose any pay, same status. We know that it's something you don't have to learn because you've done it before, so it's no transition. It'd be differently. You say, oh my goodness, I got to learn a whole new area I've never done before. Like the GSA, she did this. And then also the question whether is this unreasonable accommodation?
So I would say that it's a reasonable accommodation here, and there's no question that she got, in terms of an accommodation, setting aside the job title and the actual job, but she's getting the telework that she requested.
Right.
That's not in dispute. She's able to work the 2 days a week plus the additional episodic day as needed. That's undisputed.
Now, if the question of voluntariness is a jury question, let's just say we disagree with you, what happens to the reasonable accommodation analysis? In other words, if you can't say on this record that she voluntarily accepted this job as a matter of law, then how can you say it was a reasonable accommodation as a matter of law? There seems to be some tension there, doesn't there?
Not necessarily. The supervisory position, the agency policy was that, except for a possible 1 day of telework, the supervisor needed to be on site. that's just the rule, right? She's working, she's managing those specific buildings, her employees are in those specific buildings. The agency wants someone on site for that role, whereas the management analyst position, she's doing nationwide things. It doesn't matter so much if she's working from home or, at her desk at the office. So I would say it's a reasonable accommodation to put her in a position that's the same pay, same grade, same opportunities for advancement, of course, because she was since promoted as the previous position. Even if the court, finds it's not clear whether there was some harm, Ms. Herker cannot show that the agency's reason for her reassignment is pretext. The agency reassigned Ms. Herker due to her poor performance in the previous role, and particularly her poor performance as a supervisor. She failed to complete required reviews for her subordinates. This is a fundamental aspect of being a supervisor. Plaintiff admits that she failed to timely complete these reviews. This is at the opening brief at page 27. These were supposed to be done in April. And in paragraph 47 of her complaint on JA 12, Ms. Herker admits that she did not get to them until mid to late August. She just did not review her employees. She made the jobs of her second and third line supervisors more difficult. And the clearest evidence here is an email. This one is at JA 167 through 169. This is dated June 22nd, 2017, well before there's any mention of reasonable accommodation. And this is from Ryan Felber, who's Ms. Herker's third line supervisor. In the email, Felber asks Ms. Herker to refrain from engaging in policy disputes with other components and to utilize her chain of command. He wrote, Kelly, this is Kelly Barr, the second line supervisor, and I have been consumed as of late in smoothing over issues that have been caused by your emails. So again, this is June, well before any mention of the reasonable accommodation.
I thought so too in the record. Counsel suggests that was manufactured, that's in August. Go ahead.
Then there are numerous instances in which Ms. Herker failed to complete a task, even after several reminders, requiring her supervisor to step in and complete the task herself.
Counsel, I guess her argument, I'm sorry, your colleague's argument on behalf of her client is that even if there were whatever performance concerns there were back in the spring, nobody told her anything about it until right after she started complaining.
That's not true.
That's not.
So I'm giving you emails that are, you can see the date in the record.
They were to her, correct?
Correct.
Yeah.
So the email I just mentioned was an email from her second and third line supervisor to Ms. Herker. Here's another. She failed to get back to the Office of General Counsel. This is discussed in the briefing. Again, this is an email. This is JA 171. And the emails are between Sandra Eddington, the first line supervisor, and a senior attorney at OGC, the Office of General Counsel. And so this email is dated July 3rd, 2017. The attorney at OGC explains to Ms. Eddington that they've been waiting on Ms. Herker to supply the information since March of that year. Another one is that she didn't approve the credit card purchases of her subordinates. Again, a common task for a supervisor. There are emails from that time showing Ms. Herker's supervisor reminding Ms. Herker multiple times and then ultimately just doing it herself. This is JA 179 through 180. And this is early August 2017.
But she had started, I mean, I guess I have to look at the timeline. I thought in July 2017, she starts to sort of seek, I want a standard 2 days a week as an accommodation. But I might be getting the timeline wrong. You're saying she doesn't seek an accommodation until August?
I believe that's right, Your Honor. So I have August 21st, 2017, Ms. Herker made a verbal request for accommodation, and the site for that is JA 24. And then the formal request is August 29th, 2017. This is when Ms. Herker submits it through the
Yeah,
agencies.
right, I know the formal request is
Right.
later, but so you don't have her seeking a 2 days a week accommodation in July?
I have August 21st, 2017 is the meeting where she
No,
verbally
that's the meeting, but she hasn't asked for, I would like, okay, it doesn't matter. Yeah, so August 21st is the meeting, and that's when you would start the date, the clock running for protected activity. There's no protected activity before August 21st?
That's correct.
Okay.
So there are additional examples. This is pages 5 through 8 of the agency's brief. But in sum, Ms. Herker is failing to do parts of her job, and way too much is falling through the cracks. So that is the reason, her performance is the reason to reassign her. In response to all this, Ms. Herkert argues that the agency's reason is pretext just because she wasn't given an opportunity to improve, but she was. We went through the emails, right? She's told by Ms. Eddington, by Mr. Barr, over and over in these emails, you know, like, where is this? She knows there's a problem, she just doesn't address it. Finally, as for the failure to accommodate in count 3, summary judgment is appropriate because Ms. Herkert was granted a reasonable accommodation. Ms. Herkert requested the ability to telework. The agency allowed her to telework twice per week and requested an additional episodic day as needed in her new management analyst role. In closing, I ask that the court affirm the district court's decision for 4 reasons. First, Ms. Herkert voluntarily accepted the reassignment. Second, Ms. Herkert did not suffer any harm from the reassignment. Third, Ms. Herkert cannot show that the agency's legitimate reasons for the reassignment are pretext. And fourth, because the agency granted a reasonable accommodation, Ms. Herkert cannot prevail on a reasonable accommodation claim.
All right. Thank you, counsel.
Thank you.
Ms. Barr, you have some time reserved. Excuse me, is the light not working?
The timer is on the screens.
Okay, you know, this light not working.
We're not using
You
that.
don't use it, okay.
A couple things in response to my colleague. First, Judge Harris, you are correct with the timeline of July. She did have a conversation with Ms. Eddington. The site to that is JA 247, where the plaintiff testified that she had a conversation in July of 2017 about a reasonable accommodation with Ms. Eddington. Defendant's argument really about the
Well, she had conversations about reasonable accommodation for a long time. When she started, they even talked about
Right,
that.
I mean,
So
there
that
are-
didn't mean anything, but what does July mean?
Right, but kind of a
Okay.
more
All
formalized
right, go
at that
ahead.
time. The argument that there's only one transfer really does not make sense in the context of the email, the October 1st email that is at JA 450. I mean, the language there clearly says, effective October 1st. I'm sorry, it's a September 28th email. Effective October 1st, 2017, this is your new position. She was told to report to that position effective that date. And in response, she reached out to her 4th level supervisor. I would contend that there's no case law here that's directly on point because it's just common sense. This is not voluntary when you have a choice between 2 bad options. Choosing the lesser evil does not make it voluntary. With regard to the no loss of money, the position that she was originally transferred to, the one that she used to supervise, was a grade lower. Now, they didn't change that, and our argument is because they wanted to avoid all the red tape that goes along with that. If that was a specific demotion, I mean, that would be appealable to the MSPB. So by not making these changes, they are avoiding those requirements
It's also
to go
called
through.
reasonable accommodations too, isn't it? That's the spin you put on it, but it's also a reasonable accommodation. You don't want a person to suffer loss of benefits and payments, and you make that a nefarious act,
Well,
don't you?
in this context, yes, I think
Okay,
they are
all right, so
acting with a
everything is-
nefarious
okay.
purpose.
I see.
Because, I mean, as an like, she could do this position with 2 days of telework. They're saying that she had to be on site, but that is completely undermined by the fact that Ms. Eddington, who took over the duties after plaintiff left, was not on site. She did all of those duties at a different facility. So to say that plaintiff would not be able to do this
Was she
job for her
teleworking?
health. She wasn't teleworking, but she
No,
was
she
not
did.
on site.
Yeah, okay.
And they're
yeah.
saying the plaintiff had to be on site to do this job. But obviously, that's not true because Ms. Eddington was not on site. So yes, the loss supervisory duties, I think, is the real key here. You know, defendant is arguing that, you know, she did get a promotion again to supervisory duties. I think that just shows that those are her career goals. She has wanted to be a supervisor. That is what she enjoys. So the fact that she has been able to claw her way back up into
So
that
this transfer
position-
didn't hurt her career goals either then, because she was able to get where she wanted to go.
It's a setback. I think a setback is still an adverse action.
Well, but she wasn't a 14. She's a 14 now, right? Is she?
Actually, I'm not sure what
Okay,
the
okay.
grade
go ahead.
level is.
Argue your
But
case. Go ahead.
she is in a supervisory position. She is good at that role, so I think the agency's argument that, you know, she just didn't have the interpersonal skills to do this job and this was necessitated, is just not believable. I think there is just loads of pretext in this case, and I think the agency took these actions against her because of her protected activity and her protected class. Do you have any other questions? No? Okay,
All right.
thank you.
Thank you, counsel. All right, we will come down, greet counsel, and proceed to our next case. Mr. Cook?
Good morning.
Morning.
May it please the court. I'm Aaron Cook. I'm an attorney in Harrisonburg on the CJA panel in Western District, and here today representing appellant Stephen Perks. Mr. Zirkin and Mr. Woodward are in the room as well. They're on the brief. However, the issue the court asked us to argue about today is not pertinent to their clients. The trial court erred when it denied our Rule 29 motion for judgment of acquittal on the ground of improper venue. This is a case, I think the pertinent facts are pretty clear in the record. On 14 of the counts in the second superseding indictment, there is the same sort of recitation of the crime, and that is that on a certain date in 2020, 2021, in the Western District of Virginia, the defendants, Stephen Perks, my client, and another person, that person is a couple different people throughout the indictments, but my client and another person knowingly and intentionally distributed an amount of methamphetamine. The facts of the case are that on each of these charges, the date in the indictment is the date that the co-defendant dropped the methamphetamine into the mail in Florida. My client the entire time was living in the Florida Department of Corrections, and he would give instructions to the second named person in each of these counts to how to obtain and package and mail the methamphetamine in each of these instances. I think it may be important as we argue that 8 of these 14 shipments were in fact seized by the government. 6 were not seized by the government. Of course, venue comes from the Constitution, Article 3, and the 6th Amendment, And the Bowens case back in 2000 from this court instructs the district court to identify the conduct constituting the offense to discern the location of the criminal acts. These are the essential conduct elements, not circumstance elements like intent. In each of these situations, the conduct of mailing, of distributing the methamphetamine was all performed in the state of Florida. The government points to a couple of different things I'll talk about briefly that I do not think are effective in giving Virginia venue.
Can I just ask, I'm sorry, can you
That's fine.
just go back and, you said we look at the essential conduct elements?
Yes.
And what were the conduct elements here?
So the conduct elements of the offense in the, I think it's the Randall case, outlines the conduct of distribution is distributing, which is defined in the code, distributing a certain type of substance. And so it's the act of distributing it. And in distributing is defined in 21802, subsection 11. It means to deliver a controlled substance or listed chemical. Deliver is defined in subsection 8 as the actual constructive or attempted transfer of a controlled substance or listed chemical. And so it's our position that the delivery is a discrete event, a distinct event that that occurred whenever the co-defendant released control of the substance and put it in the mailbox.
So does putting it in the mailbox count? I mean, because the second sentence of the venue statute says if you use the mails, but you don't think using the mails is a
It says an offense
conduct
involving,
element. Okay.
let me get it here. It says an offense involving the use of the mails or transportation interstate commerce. And so this court, and all the decisions I can see on this particular paragraph are actually things like mail fraud, where the use of the mail is part of the offense.
Right, so putting it in the mail was not the,
And the district court
conduct.
cited this like in one sentence as an aside, as one basis she could rely on, but she said she wasn't relying on.
so, but the delivery, which is defined as the transfer, that's what we're looking at.
That's correct.
Okay, just as a matter of kind of like intuitive common sense, it seems like a transfer isn't finished until it's transferred.
Well, that's
Do
going
you
to be
know
the
what I'm
government's argument. The government's argument is going to be
Right,
that
well,
this
why
is
is
a
that wrong?
continuing
When you
offense.
think about transfer, I totally understand if you think about delivery maybe, it sounds more like, well, like delivered it into the mailbox. But if it's a transfer, just as a matter of common sense,
So the ordinary drug transaction would be, I hand you an item of contract, and the delivery is complete. And so it's combined with, first of all, it's about the conduct elements of the defendant. The defendant's conduct elements were in the state of Florida. So that's the starting place. So then the question is this a continuing offense? And the circuits are all over the place on this. In fact, there's unpublished opinion from this circuit going both directions, but I don't think there's been any published decisions on the question of whether this is a continuing offense.
Counsel, let me ask you, the hypo you gave, a little brief when you said, I give you the drugs and the delivery is complete, right?
Yes.
What about if I say, here are the drugs and I want you to give them to X? Is it a complete delivery complete then?
So I think we're not talking about a conspiracy, we're talking
No,
about
we're talking about
distribution.
distribution. I say, why, here are the drugs. I want you to give them to X. Is it completed when he gives it to Y?
Yes, it is.
Really, the delivery?
Yes. The conduct elements of the defendant we're talking about in your hypothetical are complete when he hands them off.
Oh, really? It's not even a question of constructive possession in the sense when I'm telling you, I'm giving it to you, but I want you to give it to X. That's not constructive
Then
still?
your mule, your runner, can then be charged with delivering the second delivery in your scenario.
But not the original person who gave the mule the drugs?
He in fact distributed the drugs to the person he handed them to, yes.
Oh, that's interesting. Okay.
So, I mean, the problem with making this a continuing offense is kind of, where does it stop, right? So, I drop the drugs in the mail in Florida, and then it travels through Georgia, North Carolina, to Virginia, and is delivered to an address. So is venue proper if the police were to intercept the drugs in North Carolina? Is that a proper venue? If the recipient in Virginia then carries the drugs to Maryland and distributes them there, is the Florida distributor liable in Maryland? And so suddenly we've opened up this huge can of worms by making, for the first time, I think, in this court, if it were to be a published opinion, to making the delivery a continuing offense. Where does it stop? And I think the way to do it is go back to Bowens and say, what is the conduct of the defendant? Where does the conduct of the defendant take place? He's certainly liable for it in Florida. Florida is the appropriate venue for this act of distribution. The government also cites Pinkerton liability as one way to bridge this gap. I would point out, first of all, as I said earlier, 8 of these, of course, Pinkerton liability is where the defendant in Florida is liable for the actions of his co-defendants in Virginia. I would point out, first of all, that 8 of these deliveries were not redistributed. There was no distribution of these items because they were intercepted by the police. And so there's no way to make these 8, I can cite the counts, these 8 proper venue through Pinkerton liability because there's no distribution in Virginia. But it's also important, I think, to look at the indictments in this case. The indictment is not that a Virginia defendant was charged with distribution and my client was also part of that count in the indictment through Pinkerton liability. The allegation is that 2 people in Florida distributed in Virginia. And so I don't think Pinkerton bridges that gap. I think it's a fairly straightforward issue that the court needs to consider, and that is whether the court wants to extend the act of distribution further than the act of distribution, and if so, how far the court's willing to extend it. And so that's, I think, the issue in front of the court. And we would ask the court to make it clear that it's back to Bowens, where the conduct of the defendant occurred is the appropriate place for liability.
All right.
Thank you.
Thank you, counsel. Mr. Gerard?
May it please the court, Keiko Juhan on behalf of the United States. If I may begin where Judge Harris actually began and talk about the definition of distribute. Congress broadly defined distribute to include the actual, attempted, or constructive transfer of drugs. And by so defining the crime, they intended to cover the waterfront of the entire distributive process, not just the second and the moment in time that the drugs, for instance, may leave the defendant's fingertips. I provide an example to the court that I think illustrates why we think that there is proper venue in the Western District of Virginia here. I first want to clarify actually our Pinkerton point. Our Pinkerton point is simply that Mr. Perks is liable for any distributions that Ms. Grote or Mosley made. And our theory in this case is that because there were attempted, constructive, and actual transfers of the drugs from Ms. Mosley and Ms. Grote into the Western District of Virginia for these counts, that venue was proper. Say, for instance, that I was to tell a friend that I was going to actually transfer, to use the phrase in Section 802, actually actually transfer $100 to him. And I put the $100 in an envelope and handed it to the mailman. I think it would be quite understandable for my friend and everyone else to look at that situation and say, you have not yet completed the actual transfer. You, Mr. Juhan, have started an attempted transfer. Maybe when you handed it to the post office, there was a constructive transfer, but there is not an actual transfer until he receives it. And so we think that that example illustrates the words and why distribution is continuing offense insofar as however long it continues. And I want to be very clear with the terminology here about continuing offense. We are not saying that because there is a conspiracy that anyone that does a distribution during a conspiracy, that crime of distribution goes on and on forever. All we're saying by saying continuing offense is that really any crime, as a matter of simple metaphysics, is going to occur across some space and time. As the venue statute says at 3237A, there's a beginning of a crime, there's a continuation, and there's an end. And so I think the question for the court here is the definitional aspect of that for a distribution. And in some cases, for instance, in the State Street example in our brief, that distribution process, that transfer process can be very brief, both temporally and spatially. But in other instances, and we submit in this case, that process can be much more elongated. I also want to speak briefly to the circuit split or purported circuit split. We actually, I would say that it is superficial, and I'd like to explain that. It is true, as we identified in our brief, that the Second and Third Circuits have said that distribution is not a continuing offense. But when you look at the facts and what they're analyzing in those cases, what they're really analyzing is a non-aggregation principle that goes to multiplicity or duplicity. They're saying in those cases the government or the defendant either charged or was arguing should be charged multiple discrete distributions in one aggregate umbrella count. And we agree that that's not appropriate. That would be like us charging counts 3 through 10 as one count. We agree we can't do that. What we do agree with the Second and Third Circuits is the statement that they've said that each unlawful transfer is a distinct offense. We agree with that. The question is just how long that transfer process for each distinct unlawful transfer exists. So in this case, we think that there's actually not a circuit split that's on the issue once you understand the substance of the continuing offense phrase, which is somewhat misleading considering the text of 3237A, which prefers not just the continuation, but of course the beginning and the end. I'm happy to field any questions that the court may have.
Counsel, Mr. Juhan, how do you respond to Mr. Cook's statement that the second sentence of 3237A is not designed was not designed or commonly used to address drug distribution, that it involves really situations, use of the mail, or perhaps, trucking or whatever. And how do you respond on that?
3 responses, Your Honor. The first, of course, is you don't have to reach that if you agree with us on this first paragraph of the section. The second response is, the second and third response basically go to case law. Your question and my friend's argument is essentially saying that the categorical approach should apply. And we disagree with that because if you look back, for instance, at DeMaya from 2018, summarizing the Supreme Court's categorical approach doctrines, what it says is, I'm quoting here, "We adopted that in part to avoid the Sixth Amendment concerns of sentencing courts making findings of fact that belongs to juries." We don't have that problem here. This jury, we're not talking about a prior conviction and its categorical elements. We're just talking about the crime at issue that this jury is going to decide. And so there is not that constitutional avoidance impetus to interpret the statute that way is one point. The second point is I spent some time late on Sunday trying to find a case, because I don't think either party was able to find one in their briefing that talked about this. And I was able to find 2 that were in our favor and 1 that was against. And so I'd like to provide those cites if I could to the court. The first case is a 2018 Ninth Circuit case called OBAK. It's 884 F. 3rd 934. It's a case where there was an 841 offense of the drugs being sent between Guam and the state of Washington. In that case, the Ninth Circuit, it's fairly brief, not very deep analysis, but said that under the second paragraph of 3237A, that venue would be proper in either Guam or Washington. The second case I found is a different type of cases, and it's actually a line of cases that the Ninth Circuit has adopted the 10th and 11th Circuit's position on regarding crimes that take place on airplane flights. And that case is Lozoya, Lozoya 982 F3rd 648, 2020 from the Ninth Circuit. And what those cases say is when there is an airplane in the air and someone commits an offense that there's federal jurisdiction over, that either the takeoff venue or the landing venue is a proper place for venue. And so then I would say that the case that cuts against us on this actually is an earlier decision from the DC Circuit in 2004. It's called Morgan 393 F3rd 192. And in that case, the DC Circuit rejected the argument that we've made here about the second paragraph of 3237A. I hope that's answered your question, Your Honor.
Can I just give you a chance to sort of respond to your colleague about, well, where is the end point for all of this? So what if the drugs get mailed from Florida to Virginia, and then, much to the defendant's surprise, the person in Virginia sells them in Maryland? Is Maryland now appropriate venue?
No, Your Honor, and I think the key word in your hypothetical, and I think we mentioned this in our brief, is surprise, is that the defendant is not going to be liable for a venue in which he's not substantively liable for the crime. And so if the defendant is working with a co-conspirator and distributes into Virginia to that co-conspirator, but then that person further redistributes in a way that there's not Pinkerton liability for the original defendant, then the defendant is off the hook, both for substantive and venue purposes. Similarly, the example we gave in our brief was an unforeseen interception, for instance, by a rival drug dealer. If I distribute into Virginia, or I'm trying to get it to Virginia, but before it gets there, my rival intercepts it in another state, well, I don't have venue or substantive liability in the Western District of Virginia.
But if the police intercept it, say, if it's not does it matter that it's a rival in your hypothetical? What if the police
I think I might have given
intercept
an unclear example. So if my rival or the police
Okay.
intercepted it in Georgia before it got up here, there's not going to be venue in the Western District of Virginia for the actual passing of the distribution. And I do want to caveat a position that we don't think we need to advance and have it advanced to win this case, is that some cases, both from this court, such as Nunez, and Brunty is the big case from the 11th Circuit, talk not just about the transfer process, but the kind of acts of arranging the distribution, almost just the coordination of, hey, let's go meet at this house. I think this was the Nunez facts. So they meet in Maryland and then they go do the distribution in DC. And this court in Nunez, of course unpublished, said that there's venue for the distribution in Maryland, even though the physical handoff took place in DC. We're not advancing, we're not saying we need that theory to win. We're just saying you can look at the hard and facts that are undisputed here that these drugs reach the Western District of Virginia. If there are no further questions, I appreciate the court's time and we ask that you affirm.
Thank you, counsel. Mr. Cook, you have some time reserved.
I guess I'll take just a few seconds to point the court back to Bowens, and that is what's essential. The district court does is look at the conduct elements, the essential conduct elements of the case.
Is that the same or different than the categorical approach?
That's different. So this is about finding venue, and they say look at the elements, the conduct elements, and did any of those conduct elements occur in the Western District of Virginia?
But you can see why it sounds like categorical, because you're looking at the elements and not what actually happened in this case. Is that right? When you say look at the conduct elements.
Right, so the elements of the offense that require conduct, if the defendant committed those in the venue, then it's an appropriate venue. And the Umanicant case goes through that, or the North Carolina case, it's a pretty thorough discussion of that. But I think what's important about that is...
But I'm sorry, just to go back to the second paragraph in the mail.
Yes.
You are suggesting that, so when we look at the second paragraph, we only ask whether use of the mails is an element of the crime, not whether in this case the offense involved use of the mails.
That's correct.
Okay, so that's the categorical approach.
I see what you're saying. Okay, yes. Yes, that's correct. So, but it just, it was put in there so that mail fraud and those sorts of interstate transfer statutes, crimes, can be prosecuted in both places. But it
And you
doesn't
think
mean
that
anytime
wouldn't
you use
have-
the mail, suddenly venue's different.
Okay, and how do I know that? I mean, that seems like it's the question,
Right.
whether it is there
Well,
only for mail fraud cases
I
or
would just say
whether
that in the Fourth Circuit, the only time that's been cited has been for
mail fraud.
mail fraud type cases.
Okay.
Cases that actually involve mail.
Because that strikes me as sort of an interesting question, whether we ought to be taking a categorical approach to that second sentence or paragraph, or whether involving the use of the mails, is just, did your crime involve the use of the mails? Okay.
And I think, I want to go back to Bowen's and the conduct elements is this. Counsel stated, and I think he's accurate, that if the package had been intercepted by the police in Georgia, then there's no venue in the Western District of Virginia. And I think that's important, because I think it'd be tempting to say that if a defendant were to write an address that says Virginia on the package, that he's somehow creating venue in Virginia. But, or creating it as a continuing offense. But I think that by admitting that if it doesn't make it, then there's no venue, it points us back to Bowen. And we find venue where we find the defendant's conduct. And so that's the one thing I just wanted to respond to. Of course, if there's any other questions, I'd be happy to.
So you don't believe that distribution is a continuing offense at all?
That's correct.
All right.
When it's accomplished, once the item is relinquished.
Relinquished. So that means that, it's kind of somewhat of a quirky hypo, but if someone is standing on the border of West Virginia and Virginia, and the provider is in Virginia and the recipient is in West Virginia, if he throws it across the line to him, then you'll say that's no distribution, no venue in West Virginia, because he released it in Virginia.
I think that's an interesting hypothetical.
I told you it was quirky.
In the sense that,
I admitted that, but you said once he releases, so then you would say there's no venue in West Virginia because he threw it in Virginia, but it landed in West Virginia in the person's hand, right?
I mean, tossing it versus handing it, I don't.
We're tossing it. That's right. But you'd have to say under your position, you'd say there's no venue in West Virginia.
That's correct.
Okay.
Although that may be an exception to other folks.
All right. Anything else?
No, sir, thank you.
He's good? All right, thank you. Mr. Cook, I note that you're a court appointed, and not only that, you're also part of our council regiment of lawyers who do that, so we doubly thank you for being here and taking these cases. It's very important to the court, and we let you know that we appreciate it very much. Thank you.
I appreciate it.
Of course, Mr. Lujan, we acknowledge your representation of the United States. We'll ask the clerk to adjourn the court until tomorrow morning, and then we'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.